Asking the attorneys in the first case to turn their videos on. Letting the law clerks in. Judge, may I open court?
Please do.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3013, United States of America versus Xavier Jamal Orange, also known as Xavier Louis Jamal, also known as Xavier J. Lewis, also known as Xavier J. Orange, appellants. Ms. Wright for the appellant, Mr. Hahn for the appellee.
Ms. Wright, please proceed whenever you're ready.
Thank you. Good morning. May it please the court. Lisa Wright for Xavier Orange. I'd like to reserve 2 minutes for rebuttal. Sentencing counsel here was ineffective in failing to raise meritorious challenges to 2 enhancements that together more than doubled Mr. Orange's guideline range, the crime of violence enhancement and the extended magazine enhancement. As to the crime of violence enhancement, that was applied to Mr. Orange's prior attempted assault with a dangerous weapon or attempted ADW. In 2018, this court in Brown relied on the attempt commentary in finding that attempted ADW was a crime of violence. But by the time of Mr. Orange's sentencing, the Supreme Court had decided Kaiser, and after Kaiser, it was clear that the attempt commentary could not be relied on to expand the clear text of the crime of violence guideline. And indeed, the government does not claim that the text of the guideline contains any genuine ambiguity that would justify deference to the Sentencing Commission's commentary. So looking just at the plain text of the guideline, it's clear that DC attempted ADW does not, quote, have as an element the use, attempted use, or threatened use of physical force against the person of another. Because even
if we're starting with text of the relevant guideline is 2K 2.1, correct?
yes,
And that guideline says use the meaning given in not just 4B 1.2, but 4B 1.2 and the application note. And the application note to 4B 1.2 expressly includes attempts.
so which section of 2K 2. Is that referring to an application note in 2K 2.1? I'm sorry.
Yes.
Yes, the application note 1. Yes.
It says crime of violence,
Right.
which is undefined in 2K,
Right.
has the meaning given that term in the text of 4B 1.2 and the application note of 4B 1.2. So even if you were correct that in a 4B 1.2 case, the application note in 4B 1.2 goes beyond the text of 4B 1.2, this application note says use the other one, which picks up attempt.
Well, I mean, if it's simply a cross-reference, so I guess I would say that to the extent the cross-reference commentary is basically invalid under Kaiser, it can't be incorporated through another commentary to 2K 2.1. I mean, it's still just commentary, and it's just really invalid under the circumstances. I mean, I don't think the government's even claiming now that the commentary, is effective. And of course, the same language is interpreted in ACCA and other statutes without any commentary. So it does seem like it's surplusage to some degree.
That's fair. Both sides treat 2K 2.1 as coextensive with 4B 1.2. And maybe that's a perfectly good answer for you. I'm just not sure it's right, but go ahead.
Okay.
Ms. Wright,
yes.
can I also ask you, how should we think about Kaiser in the context of the guidelines? Because the guidelines are themselves not binding and the commentary is not binding. So we're looking at a non-binding interpretation of a non-binding guidelines. So does Kaiser even apply in that context?
I think so. I mean, Congress does approve the guidelines, and the commission, passes them through a formal process. And then the commentary, Stinson said that Stinson said that the commentary was entitled to some deference. And Stinson has basically been restricted now by Kaiser. So I guess Stinson treated the guidelines like other regulations, more or less. I understand it's not exactly the same, and certainly in Winstead, Stinson was treated as applicable to the guidelines.
Well, but in Winstead, that was at a time when the guidelines were still treated as binding. Right, because wasn't, yeah, I think so.
Oh, well, the case was only a few years ago. I guess I'm not sure of the year.
Well, maybe
I think it was post Booker that sentence occurred. I'm not.
Yeah.
I think it was like 2011 or 12 that he was sentenced. So that was post Booker. So, our argument looking at the text is very simple, that because even a completed assault only requires, either an attempt to use force or a threat to use the force with, through use of a weapon. That
this case all comes down, does it not, to the argument that an attempt to threaten exceeds the crime of violence.
That's right.
That's the key issue in the case.
It is. I think technically an attempt to use force is also a step removed, but I think it's a lot clearer when you think of it in terms of attempt to threaten, that our point is much clearer. And it's just one step removed from what is called for. And the government has now acknowledged that a defendant can satisfy the elements of attempted ADW by attempting to threaten use of force against a person, for example, by getting a weapon and traveling to get the victim with the intention of committing an ADW by threat, or that is by, an intent to frighten ADW with a
the government's argument is your position is really artificial. Never in a million years would anybody be prosecuted for an attempt to threaten.
That was their argument, I think, but I unless I'm misinterpreting the letter they sent yesterday, I think they're acknowledging now that such crimes do exist and do equate to assault with attempted assault with a dangerous weapon.
I'm sorry, I didn't see the letter yesterday.
It's just a simple one paragraph letter, if I can pull it up.
I have it. It says.
I see it. I see it.
It concedes that the statute covers the hypo everyone's talking about the defendant who goes to the victim's house and is picked up on the doorstep.
Greg, you mean the guidelines, not the statute?
I'm sorry. Yeah.
Yeah.
So
yes. So what's? I'll be interested to hear what the government's case is now.
Yeah, with that out of the way, it just seems like clearly counsel failed to raise a meritorious objection, and whether or not, the only issue really remaining is should he have seen it? And I think that given that he was pointed
No, there's another issue, an important issue in the case, which is there really any prejudice? It's hard to imagine a district judge more annoyed at a defendant and more anxious to impose a tough sentence regardless of the guidelines.
Right. I mean, I was going to deal with prejudice separately. I guess I would say the only issue as far as whether he was deficient was whether he would have recognized it. And we think that because of the sort of breadcrumb trail he was given to Winstead and Stinson and you know, basically Kaiser is all about the Seminole Rock deference that was discussed in Winstead. And if you Google, I mean, if you Westlaw Stinson, up pops Kaiser. So he should have seen it. Now, but I'm happy to address the prejudice. I mean,
yeah, just before you get to that, so just one
Yeah.
question on deficient performance, which is, I mean, it has to be more than just failing to raise an objection that turns out to be meritorious, right? Because otherwise Strickland completely swallows up any obligation to preserve issues.
I understand what the court's saying, but I think that in this case, that there is a foreshadowing, or what I guess they talked about, the building blocks in Bridges. And also in Winstead, there was a discussion of like, this was out there, this was available, and why wouldn't you raise it if there's something that creates these building blocks for you? And I would say there were special circumstances here, even in that really alerted counsel that he needed to dig in and find this, or look at the thing carefully. I mean, you don't even have to look that carefully, honestly, but the fact that the enhancement was a surprise, the government wasn't arguing it. And even after the PSR, I guess at that point, the government did, well, that's a little unclear, but the point is, it's a red flag when the government has agreed that something doesn't apply, and then it comes up as a surprise, and it creates such a large, addition to the guideline range. And also, I think it's pretty established that this categorical, first of all, defense counsel's ability to understand the guidelines is like a core competency of a defense lawyer, including the categorical approach. And really, the fact that it may be counterintuitive sometimes or result in some odd outcomes is almost more the reason that you don't assume anything, and that he should have carefully looked at this. And of course, Brown itself says there's no Stinson argument here. All he had to do was put Stinson into Westlaw, and he would have seen, oh, look, Stinson's been even narrowed more greatly, and there was already Winstead. So I guess I just think there couldn't be more of a taking him by the hand to find this issue. So even if you may not, if you're the only first person to ever think of something, maybe, but when it's out there, what is the justification for counsel to not raise it, is what I would say.
Was this an assigned counsel?
I'm not sure if he was retained or appointed. I'm not sure. It was a person outside our office, but I don't know. I can't remember. I think he may have been retained, but I don't want to say that for sure.
You don't dispute the general proposition that the error has to be obvious. You're just saying this one was.
It was obvious. I mean, it has to be, obvious, available.
Which case do you think made it obvious? Winstead or Brown?
I guess Winstead, but Brown pointed him to Winstead, and then Stinson also, and Kaiser. I mean, Stinson and Kaiser and Winstead, with those three, it's there. And
gee, I agree with you that Winstead was really a major opinion. I'm teasing, of course, since I wrote it.
Brilliant opinion.
Indeed.
Backbreaking.
I want to point out too that counsel
more on deficient performance.
Okay. Yes, go ahead.
I am interested in prejudice as well. But
okay. I was just going to point out that counsel, it appears, wasn't familiar with the categorical approach at all. So, I mean, that's a little bit of a flavor here of kind of.
Yes, he wanted to go over to the Superior Court to check the facts of the case.
Correct. So, I mean, it does seem like he was in over his head on this whole issue, but a little bit of digging would have brought this up. So So on the prejudice, I wanted to, if we're turning to that, I guess if the court's referring to the, I mean, obviously when the guidelines change, there is, Martinez, Marina Martinez, I think it is, I'm saying, not getting that correct perhaps, but indicates that normally, of course, we would assume that there's a reasonable probability that the sentence would change. And we understand that here,
unless the district court otherwise makes clear, and this is clear as can be.
Well, it's not, what it doesn't do. It's just general. It's just saying, whatever the guidelines are, I would give you this sentence. And if that is enough, then that is
no. He went further. He went further, actually commenting that the prior sentences were inadequate, and that this fellow was really dangerous with his arsenal of guns. I mean, it was pretty. It was dripping with the judge's comments were dripping with concern that this fellow should be put away for a long time.
Well, that's true, but I would say that the judge was not addressing a specific alternative and saying, if this, then I would still do that. He wasn't even aware of these issues. This isn't a situation where defense counsel says, I object to such and such, and the judge says, well, I disagree with you, but even if you're right, then the judge knows what he's considering. Here, these are issues the judge couldn't have considered them and justified a variance from these ranges when he wasn't aware of the arguments that made these ranges appropriate. And I don't see how.
But think of how this issue comes up. The government makes a deal on the assumption that neither adjustment applies, and it produces one range. Then the probation office figures out, oh, well, maybe one of the two ranges, one of the two adjustments applies, and it produces a different range. And then the judge figures maybe the second adjustment applies, and it produces a third range. I mean, that's a pretty structured decision tree of figuring out which of the two options applies, and that leads you to a defined guideline range. And that's the background against which he says, regardless of whether the adjustments apply, I would come out to this sentence.
Well, I don't think he was referring at all to the crime of violence enhancement. He didn't have any, he specifically asked counsel, are you objecting to that? And he said no. So at that point, that's off the table. I mean, that is not what the judge is thinking about when he's saying that he would vary. I'm not saying he can't vary, but he needs to, under Gall, he needs to, and under Parks, this court's decision in Parks, he needs to explain why the particular range that he's alternatively considering isn't sufficient. And here it was just a lot more general than that. And if we allow, if court can just say that sort of general statement that this person's terrible and this is the sentence I would pick no matter what, that's no different than not making the judge calculate the guidelines at all, because it totally insulates the guideline calculation.
That's right. Aren't those standards, though, the standards that you're stating, the standards we would apply on direct appeal? Whereas here we're just trying to consider the question of prejudice and whether there's a reasonable probability that the judge would have given the same sentence, which I think from the record here, it's amply clear that there's certainly at least a reasonable probability that he would do so.
Well, I think the reasonable probability standard is very favorable for us. It's a very low standard. And it's generally satisfied whenever the range changes, because otherwise what's really happening here is the judge is just saying, I don't care what the guideline range is, but yet he seemed to care what the guideline range was when he thought it was 46 to 57, and he picked the high end of it. And then, it's a bit of a, I guess I would say somewhat of a, he must have cared about the range, because otherwise it's kind of a strange coincidence that the one number that is the sufficient but not greater than necessary number.
If the exceptions in Molina Martinez don't apply here, like what would the district judge have to say in order to?
he would have to say that even if your range, even if you're at level 14, or even if you're at level 20, which were the, I guess, say if you were at this range, this, not just that I would do it, but I would do it because that range justifies a deviation of 30 months. If it was really 21 to 27, I would find that a deviation of 30 months was justified because of the following reasons. And also I would, whatever range we're talking about, he needs to think about that extent of the deviation is what I do.
Do you have any cases where court has imposed that type of standard in ineffective assistance context?
I guess Parks is not, I'm not recalling the exact context of Parks, whether that was an ineffectiveness or I'm not sure. I have to double check that. I'd have to think about that. I mean, there's many cases where this court has said that that's what you have to do. And that's what Gall says you have to do. You can't just say, and this court had a case at the very before Gall, I think, where a court was saying, I don't even need to calculate the range because I'm telling you right now, this is the sentence that's sufficient but not greater than necessary. And this court said, you can't do that. And then Gall came out and said, that's right, you can't do that because you have to calculate the range as a starting point and an anchor and a benchmark. And then that creates a gravitational pull that you have to pull back against. And you got to know how much gravitational pull you got to overcome to get to the 57 months here. Was it 30 months? He wasn't even considering that the range might have been 21 to 27 because nobody had argued that had been given up. So I don't know if the court is interested in hearing about the extended magazine at all, but I'm obviously happy to argue that, but there's no other questions.
It's pretty straightforward from the brief. So thank you, Ms. Wright.
Thank you.
Questions from my colleagues? Thanks, Ms. Wright. We'll hear from you, Mr. Hahn.
Thank you, Your Honor. May it please the court, Brian Hahn for Appellee, the United States. Appellant's trial counsel in this case did not perform deficiently by not challenging the crime of violence enhancement or the high capacity magazine enhancement in the way that appellant claims on appeal.
Here's my question.
Neither
Excuse me, counsel. Here's my question to you. Isn't the question of the categorical nature of a past crime fundamental to Supreme Court in our cases? And isn't it rather clear that this counsel appointed or retained didn't even understand this fundamental point of the categorical nature of the prior crimes?
I would agree that the categorical approach is the way that it's fairly well settled at this point.
No, but I'm saying that this is so fundamental, and this counsel obviously didn't understand that, which is sort of astonishing. That comment, I have to go over to the Superior Court to check the facts, is almost a dreadful indication of ignorance.
Well, I think that what happened in this case, and especially that comment, is that, maybe he was speaking out of turn, maybe he wasn't quite clear at the time, but the court did give him a continuance. There was a continuance in the sentencing, and he was able to at least look into the issue and later say that he wasn't challenging the enhancement. And so I think that if he had looked
into the issue and decided the categorical approach didn't help him.
Yeah, I think that if he had done that, he would have.
I don't recall anything in the record that indicates that.
Well, I don't think that he made any comments after the sentencing. He didn't explain why he wasn't challenging the enhancement after the continuance. He just said that he wasn't. But if he had looked at the case law, of course, he would have found Brown. And Brown says, even though it does leave open this sort of Stinson-Kaiser argument that appellant is raising now, Brown does say that assault with a dangerous weapon is a crime of violence, as is attempted assault with a dangerous weapon. as a crime of violence under the sentencing guidelines. And so I think that counsel, even if he was not fully prepared at the time the judge raised for the first time whether or not this enhancement applied, that he was given the opportunity to do the work and came up with a decision that
But he
to
did
not challenge
not,
the
he did
crime of
not
violence.
consider the point that you concede in the letter you filed yesterday. He did not even consider that.
Well, I think we just don't know what he considered or not.
Well, he
because,
didn't
of
say
course,
it.
This is
He didn't
he did
say
not. That's correct, Your Honor. He did not say that he considered it, and I think that given the posture, this is why this court often remands ineffective assistance of counsel claims if they could be meritorious for hearings in the first instance by the trial court judge. That's why the Rashad standard exists.
Wait, you want us to remand?
No, what I'm saying is that if this court believes that the argument would have been meritorious, then yes.
You think we have to remand
If
to
this,
inquire into why he didn't raise it? You don't think you have a different argument that this was a debatable enough legal question? I mean, we have Harrington versus Richter and Deuced and lots of cases that say it's not deficient performance to make a reasonable mistake.
no, so I agree with that, Your Honor. I agree that both our legal argument has to have been obvious and that it has to be meritorious. And so I think that, in sort of discussions you've been having with appellants counsel, I think Winstead, in fact, says this, that the error in Winstead that counsel made, the legal argument he should have made, was an obvious one. And that in this case, this legal argument wasn't an obvious one. And so
that's a fair point, because the hypothetical of an attempted threat is almost in some respects metaphysical.
I think that's right, Your Honor. And I think, it's important to understand that attempted assault with a dangerous weapon, at least I'm not aware of any cases in DC that talk about it as a standalone crime. And generally it comes up as part of plea bargaining, that the defendant and the government agree for the defendant to plead guilty to attempted assault with a dangerous weapon instead of just assault with a dangerous weapon, because it inures to the benefit of the defendant. It reduces the maximum sentence. It reduces the sentencing guidelines, the voluntary ones in DC. And so that's usually attempted assault with a dangerous weapon is sort of a creation of plea bargaining there.
Put aside for a second the question of deficient performance and the question of what the government would charge. So just as a matter of substantive criminal law, do I correctly understand your letter from yesterday to concede that Ms. Wright's hypothetical, the statute does cover that hypothetical?
You mean the guidelines?
It is attempted. I think I mean the statute. It is attempted ADW under DC law when the ex-boyfriend is bringing the gun to wave it around, never intends to commit a battery, and the police stop him. That's
correct, Your Honor.
Violates the statute, even though, right? So why isn't that enough to make this not a crime of violence under the categorical approach? Because that's one hypothetical nonviolent application.
So I think it's because, the threatened use of force encompasses that. I think that when the boyfriend is traveling with a gun, intending to threaten his ex-girlfriend or partner or what the case may be, that because he has committed a substantial step towards committing an assault with a dangerous weapon, intending to threaten this person with a weapon, and he has the intent to do so, that he is threatening the use of force there. And I'd also argue that, in fact, the use of the dangerous weapon here also makes threatening that threatening behavior a use of force, because whether or not as this court said in Brown, adding a dangerous weapon makes a crime inherently violent and materially increases the risk that violence will ensue. This is 892 F3rd at 403, and because attempt requires the intent to commit every element of the offense. This is including the use of a dangerous weapon to threaten someone. That also makes this attempted assault with a dangerous weapon a crime of violence. Yeah.
Okay.
That sounds like how many angels can stand on the head of a pin.
I'm not sure that's quite right, Your Honor. And I think that the plurality of circuits at least agree that that's the case, that attempted crimes of violence such as Hobbs Act robbery and various murder statutes are in fact also crimes of violence, even though, for example, Hobbs Act robbery can be committed by putting the victim in fear or using intimidation.
Right.
And
you agree with the Taylor opinion of the Fourth Circuit.
I do not, Your Honor. It's a good try, but I I think that Walker, St. Hubert, Smith, Dominguez, those cases have the better argument.
If we disagree with you on the substantive criminal law point and think that the attempted threat hypothetical does not involve violence, but we also think that the defendant hasn't shown that a case like that would ever be prosecuted, how should we come out?
I think that this court could follow the path that the Second Circuit took at McCoy in that case. That in that case, as McCoy says, and I think quoting a Supreme Court case that I can't remember at the moment, but we need to look at the categorical approach, not hyper-technically, but realistically. And that if there isn't actually a situation where this ever practically would come to light, that it should still count as a crime of violence under the categorical imperative.
Does
categorical approach, sorry.
That comment about don't use too much legal imagination, does that go to the scope of the law or what the government is actually prosecuting?
I think that goes to the scope of the law, Your Honor. I don't think that's a choice by the government whether or not to prosecute it. And I think that the reason why that is because McCoy points to whether or not there are any cases that talk about that specific scenario. If there are no further questions, I would just say also that in this case, there was no prejudice to the defendant, to appellant here, because as the trial court said, no anything less than a sentence that he was imposing would not be sufficient to comply with the purposes of sentencing. And the court made very clear that there is no reasonable probability that appellant would have gotten a different sentence, even had the guidelines been different. Thank you.
Ms. Wright, we'll give you 2 minutes.
Thank you. I wanted to sort of make 2 points. One, on the obviousness, I just wanted to say that I think it is as obvious as Winstead, because an attempted threatened use of force is not a threatened use of force any more than an attempted burglary was a burglary in James or attempted distribution was a distribution in Winstead. It's exactly the same. So I do think it's equally obvious. I don't know that I want to get too much on the head of the pin, but I do disagree that this threat is in any way metaphysical. It's not solely the creation of plea bargaining. And frankly, even if it is, that's often because the victim is claiming something that the defendant denies about the use of the weapon and whether it was actually used. And a defendant, there's a dispute there. And so the government agrees to, that they're not confident that they can prove ADW, so they go on the defendant's version of the facts. But it's not solely a creation of plea bargaining. These crimes do happen. I mean, I just yesterday was seeing in the paper, it's not exactly the same, but you can see how this could happen, that somebody came to Washington and they texted a friend a threat to a member of Congress. And they said they were going to use a weapon to injure this person. And this person texted the friend texted the person's mother called the police went to the hotel room and got this person and prosecuted him. Now, because he had not actually driven over to do this, it was prosecuted as a threat. But if he had left the hotel room and headed over and they had stopped him after a substantial step had taken place, he would be prosecuted for attempted ADW, whether he said, I'm going to injure this person or I'm going to scare the heck out of this person with my Second Amendment device. So I just think—
Counsel, let me pick up on what Judge Katsas was asking. Although I agree with you that a lawyer who doesn't understand the categorical approach would itself be bad evidence of insufficient counsel. But even if you did, would it be remotely obvious to think of an attempted threat? Isn't that a rather sophisticated and not obvious hypothetical?
I don't think so, because the crime is an attempted ADW, and everyone knows that an ADW is an attempted or threatened use of force. So when you add that extra layer in there, that defense counsel's mind is instantly going to go to that word attempt and think, wait a minute, how does this help me? This is not as serious as an ADW. Oh, ADW itself only satisfies attempt and threat. So this is not included. It's really not complicated, particularly, like I said, it's just as simple as attempting to do the thing in the statute isn't doing the thing in the statute, just as it wasn't in James and in Winstead. And on the metaphysical or the likelihood of this happening, I mean, I just think that we're talking about an area that is very different than Hobbs Act robbery, for example. So even if Taylor is wrong about the likelihood of that being prosecuted, the ADW is very different because, first of all, it doesn't have that extra element of actually having to get away with the loot. So in a lot of attempted Hobbs Act robberies, they do everything, all the forces employed, and they just, because there's some victim resist or whatever, they don't get the loot. But in domestic violence also, the people that commit these attempted ADWs, they are so out of their mind that they broadcast. They're not hiding it. They're telling the person that's sitting next to them in the car, I'm going to head over and do this. They tell their roommate, they confess, they say, oh, I wasn't going to do anything, I was just trying to scare her. So these cases exist, and you can't prosecute them for ADW if they don't get close enough to do it. But I can't imagine why in the world the government wouldn't want to put these people away for attempted ADW. So unless there's further questions, I'd like to ask the court to remand for resentencing with effective assistance of counsel.
Judge Rao, anything else? Judge Silberman?
No, thank you.
Ms. Wright. The case is submitted. Please call the next case whenever you're ready, Madam Deputy.
Which is next one?
Case number 20-1286 et al. Wabash Valley Power Association, Inc., petitioner versus Federal Energy Regulatory Commission. Mr. Elliott for the petitioner, Ms. Pasella for the respondent.
Thank you.
Mr. Elliott, good morning.
Good morning.
Please proceed.
Thank you. May it please the court, this petition concerns Ferc's flawed interpretation and application of the Supreme Court's Mobile Sierra Doctrine. The court's review of Ferc's interpretation of the Mobile Sierra Doctrine is de novo. Ferc's orders do not explain why the rate and the rate setting procedure in these 20 long-term wholesale power contracts is not protected under Mobile Sierra.
Here's a question I have for you, counsel. I was trying to understand why this structure would be set up, whereby there's a board of directors really dominated by the distributors. And that, if I understand correctly, the distributors actually own Wabash. Is that correct?
That is correct. And that is,
So what we have in this case is the distributors are paying themselves.
in effect, yes, yes.
And if they're paying themselves, how can it be argued that there is equal bargaining power? Isn't that meaningless?
No, it is not. I mean, there are 20.
In other words, this distributor has, in some respects, has an interest in having a high rate because it's going to get the benefit back on that. So how can it, even if Mobile Sierra applies, how can you be saying there's equal bargaining power when in fact the distributors are on both sides of the transaction?
Well, there are 20 bilateral contracts between each member owner and Wabash Valley. And you are correct, the distributors own Wabash Valley. It is formed.
So they are on both sides of the transaction.
Not in the sense of
In economic reality,
contracts are not arm's length deals, because each of the 20 distribution co-ops is a separate corporate entity with its own interest. They have a common interest in.
Am I not correct on my proposition that the distributors are on both sides of the transaction?
As a matter of corporate law, that is not entirely correct, because Wabash
in economic terms.
In economic terms, they have a common interest in Wabash Valley procuring the lowest cost rates. And they have a cost of service.
They also have a common interest in having Wabash get a high rate.
No,
they get the economic benefit from that.
Well, it would be a complete wash. I mean, what the Wabash Valley is a nonprofit. It passes through its costs to the 20 member owners. So Wabash Valley either builds generation or it purchases wholesale power in the wholesale power market on behalf of the 20 members, and then passes through the costs that it incurs to these 20 members under their long-term contracts and the formulary rate tariff. So it has
let me just
a complete pass-through entity. So the 20 members have an interest in Wabash Valley holding down their costs and making the rate to them as low as possible, because it's a nonprofit.
Perhaps, but they also get the benefit if the rates are higher.
Well, they're not affiliate. Yeah, I mean, there's a flavor in Ferc's in some of Ferc's orders, particularly the orders involving RTO transmission owners, in which they have a common interest as transmission owners joining an RTO in excluding other competitors. And Ferc likened that to a lack of arm's length bargaining to entities that were merging or entities that were corporate affiliates. But that's simply not the case with these co-ops. They don't have that kind of common interest. They're not trying to exclude other competitors, and they have no interest in Wabash Valley increasing the rates to them. Because the distribution co-ops themselves are nonprofit entities, and they have to pass through whatever costs they incur to their end-use consumers that own them. So the entire interest of all of the co-ops is to keep their costs down.
Counsel, when a judge tries to ask a question, you're supposed to pause.
I apologize, and I know better. I'm sorry.
All right. Now, with respect to the two members who did not wish Titmont and the other one who did not wish to agree.
Yes,
How much bargaining power do they have?
they have equal bargaining power with the other members.
Well, once the majority has voted against him, what bargaining power do they have?
Well, they've agreed in their contracts and in the bylaws of Wabash Valley to the democratic organization and governance of Wabash Valley. So,
But isn't it fair to say they had very little bargaining power at this point, once the majority have voted against them to adopt the public interest standard?
Well, let me clarify the record. I don't think either of the two, we don't know why the two co-ops who did not sign these contracts did not sign them.
They have the same bargaining power as any other owner, but they may have very small bargaining power relative to the joint venture, the corporate entity, right?
This is true.
Which makes this case arguably different from a classic mobile Sierra, where you have equally powerful entities on both sides of a wholesale power transaction.
It is unique in that the distribution cooperatives are both the wholesale customers and the member owners of the DNT.
It's
different,
right? I mean, the owner seems very small relative to the joint venture, which to me is a fact that cuts against you. On the other hand, the fact that this is a joint venture, and Judge Silberman's point about being on both sides of the transaction, I had thought that sort of cuts in your favor, because you might think that this is a group of people just making arrangements among themselves rather than unilaterally imposing tariffs on economically separate entities. It just seems to me it's different from the classic mobile Sierra one-on-one large wholesale entities.
You are exactly right. And I think that is our point, that it is a multilateral deal involving multi-parties long-term, and they want to protect it from being attacked either by one disaffected member or by an outside entity or by the commission itself. And that's the very purpose of Mobile Sierra, is to protect a long-term contractual arrangement like that.
If it's different in that way, why wouldn't we give Ferc a measure of deference in assessing whether this is the kind of transaction likely to produce a just and reasonable rate, either because of the economic power or the ownership relationship?
Well, I believe the problem, and I think as a abstract matter, you are correct. They would get some deference in applying the facts to the law, and in this case, we think they have misstated the law, and we've explained that in our brief, why they've added additional restrictions on Mobile Sierra that are not in the case law, and they haven't really explained why the facts, which seem to be undisputed here, lead to the result to reject the application of Mobile Sierra to this, for the reason, the policy reason that you gave, that this is exactly the kind of thing that should be protected by Mobile Sierra.
Mr. Elliott, one of the things that I think it's important to clarify. I mean, I think some of this discussion goes to whether Mobile Sierra should apply to the new contracts themselves, as opposed to whether that standard should apply to the types of changes that are mentioned in section 22. And so I guess I have a couple of questions about that section. So section 22, the briefing focuses a lot on the second clause of that, that there could be a unilateral change to the tariffs. But I guess I'm not sure I understand how the second clause fits with the first clause. So the first clause suggests that there can be no unilateral changes. And then the second clause says, well, if notwithstanding the foregoing provision, a modification is made unilaterally, then, we apply the Mobile Sierra presumption. So I guess if you could just explain to me what is, how does section 22 work?
Yes, it is a classic among utility lawyers, Mobile Sierra clause. The first clause waives the rights of the utility, of any of the parties, to unilaterally file a new rate or to file a complaint under the ordinary, just, and reasonable standard to effect a rate change. So it's bilateral waiver of rights under the ordinary Mobile Sierra clause. The ordinary, just, and reasonable standard, if you will. That's basically what Mobile and Sierra allow. Parties can bilaterally waive their rights to change the rates. And so that's the first clause. The second clause is if you will, a clarification that if any party nonetheless attempts to file a complaint, it's governed by the public interest standard. And that's because the courts have held that you cannot waive that public interest, the ability of a party to complain under the public interest standard. So that's non-waivable. So the first part waives everything to the maximum extent possible. The second clause explains that where it cannot be waived, the public interest standard applies.
So how does that second clause then interact with the cases which suggest that Mobile Sierra doesn't apply to contracts that indicate there could be a unilateral change to the rates? Like, does the second clause suggest that there can be unilateral changes? That means the presumption doesn't apply?
Right. There are so-called Memphis Clause would be is an example of that. That would be a contract that says we agree to pay, for 10 years, we'll buy power from you at whatever rate is then you filed and is approved by Ferc. And that would be a waiver of the right to a fixed rate by the purchaser and the seller, and it would preserve the seller's right to unilaterally replace the rate at any point. It would also preserve the buyer's right to unilaterally say this rate is too high and needs to be replaced at any point. So it would essentially remove the contract from the protections of Mobile Sierra. And so that's one of the beauties of Mobile Sierra, is that it allows the parties to devise in their contract what protections they want and do not want. And that flexibility, whether it's to agree to a stated rate that's fixed for a long time, or to a formula that is a formula that's agreed upon, but whose the input values would vary from year to year, which is what Wabash Valley has in place here. So Mobile Sierra protects that. I think it also protects an agreement like this, where the purchasers, the distributors here, have agreed to allow the Wabash Valley Board of Directors to devise the tariff and to.
Right. So I guess my question is whether the tariff itself here is a contract rate or not. Mm-hmm. The second, I mean, whether it is or not, the second clause of section 22 seems to suggest that there could be a unilateral change to the tariff. And it seems to me that partly what Ferc is saying is that Mobile Sierra doesn't apply to those changes because they're unilateral.
Well,
so even if the tariff itself was a contract rate.
Yeah, I'm sorry.
I said, even if the tariff was the formulary tariff was a contract rate, a unilateral change to that tariff would not be part of the contract rate, and so therefore not get the Mobile Sierra presumption.
Yeah. I'm not sure if that's Ferc's rationale, because they just basically say it's a tariff and it doesn't Mobile Sierra does not apply, period. But embedded in the idea of a tariff in the all of the case law is the idea that you just expressed of the ability of the seller to unilaterally set the rate. That's what a tariff is. And that's lacking here because Wabash Valley's management cannot unilaterally change the rate. It's the board of directors controlled by the members, and that's preserved in the contract. And that's an important distinction in that, as Judge Silberman said at the beginning, it in some sense puts the distributors on both sides of the contract, but it enables them to control the rate and to through the board of directors that is charged to them and to contain the cost. So in that sense, it's not unilateral. It is part and parcel of their contractual agreement with Wabash Valley and by extension with each other to have this tariff be the rate that is in every contract. That's a feature, and that's deliberate. Everybody wants to be charged the same rate and not be discriminated against. And by design, they have incorporated in each contract a common tariff. They could have written it into each contract, been more cumbersome. They've done it this way, and I don't think that makes a difference legally for Mobile Sierra.
But isn't it fair to say, going back to my point, that the distributors have somewhat less incentive to insist on the lowest price because they get the benefit economically of a higher price? So therefore, couldn't it be argued that the consumer is hurt then possibly by this arrangement? Because FERC can't use its normal standard of just and reasonable.
Mm-hmm. Well, I would begin by saying that FERC accepted this cost-based tariff in 2005 as just and reasonable, and that's an important point that I want the court to know. That's not changing here. It's just a new set of contracts that are continuing to use the same existing cost-based tariff that FERC long ago approved. So FERC has already found that the consumers are protected by this cost-based rate. But
we're talking about future changes. We're talking about
yes,
future changes.
Yes, but this entire enterprise, I mean, the members have boards of directors and they're controlled by consumers. And the Wabash Valley then is in turn controlled by the distributors through its board of directors. So this is a consumer-owned, consumer-governed enterprise.
Well, it depends on who you're talking about as a consumer, not the house that buys electricity. But you see the point.
Well, it's a two-level cooperative, a cooperative of cooperatives, but
what's
in the end,
reason?
they are all.
May I ask you, what is the economic reason to set up this unusual structure?
It's not unusual. There are 65 of these entities. They cover much of the country. Wabash Valley is very typical.
Well,
only about 8 of them are regulated by FERC.
Well, okay, what is the reason for
the reason is economies of scale to build generation on their own or to acquire it through long-term wholesale power contracts. That Wabash Valley, it's a much larger enterprise than any of the small distributors. It has more bargaining leverage and more technical capabilities. It's just able to procure rates at a more competitive, lower cost than the individual distributors could on their own. They were set up mainly.
Let me go back to Judge Katz's point. Although in the Morgan case, Justice Scalia said we could affirm on any grounds. We wouldn't have to remand. I still have, his point seems to me very powerful, that this is an arrangement which is really not contemplated by Mobile Sierra at all. It's an unusual situation compared with the hypotheticals that Mobile Sierra deals with. So therefore, why shouldn't we defer to FERC on this?
Well, Mobile Sierra says that contracts freely negotiated are to be presumed to be just and reasonable under the Mobile Sierra Doctrine and protected. The fact that this is not an investor-owned utility selling to 20 distributors does not change the fact that these are long-term contracts that are used by the distribution co-ops and the G&T that they're a member of for purposes of investment. I mean, a G&T cooperative goes into the capital markets to get loans in order to finance its generation purchases and its generation building. These are large, they go to Wall Street for money. Protecting these long-term 50-year contracts is the lifeblood of a G&T cooperative. That's why the policy of Mobile Sierra would apply here even more strongly than it would in the case of a bilateral power contract like in Morgan Stanley.
What prompted the Wabash, the board of directors, to wish to add in the new contract the public interest standard rather than just and reasonable?
To protect
Well,
the
rather
contract.
than, when I say, I shouldn't say rather than just and reasonable, rather than just and reasonable as implemented by Ferc.
Yes. To provide further protection of the contracts from either being modified by a single member who could file a complaint at Ferc and upset the whole apple cart for everyone. They don't want that to happen. And so all the members agreed not to do that. It's to protect the integrity of the contracts. I mean, it's just
Mr. Elliott,
ensure
maybe
that
a related question to what Judge Silberman just asked. I mean, can private parties change Ferc's standard of review by contract? I mean, so either Mobile Sierra applies because there's contract rate or it doesn't, but why does it matter what a private contract says about the standard that Ferc should apply?
Well, that is a good question. I mean, I think if Section 22, that second clause of Section 22 were not there, the contract would still be protected by Mobile Sierra because that is the default rule. So if the parties agree to a long-term contract and they waive their rights to change it during the term of the contract, that's Mobile Sierra.
So then why does Wabash care? Why does Wabash care if this clause remains in the contracts?
Well, it clarifies. I'm sorry.
No, I mean, since Ferc rejected the contracts without prejudice, I mean, why not resubmit the contracts without this clause? I mean, I guess just practically speaking, what is so important about including this clause in the contracts?
Yeah, well, given Ferc's rationale in this order, and then they noted they've repeated it in a couple of other recent orders involving other distribution co-ops that have become newly regulated by Ferc, unlike Wabash Valley, which has been regulated for years. Ferc has essentially said the tariff, a G&T cooperative cannot adopt a common tariff that applies to all of its members, whether that is a stated rate, as in the tri-state case, or a formula rate, as in the case of Wabash Valley, and then have it protected as Mobile Sierra. And before the orders in these cases, I think Wabash Valley would have presumed that its formulary rate tariff was protected because it's part and parcel of their contracts. Given Ferc's order now rejecting these three words in the Section 22, the implication seems to be that any member of Wabash Valley or a third party who wants to cherry pick off some of the members of Wabash Valley and come in and could attack the formulary rate tariff and say that it's unjust and unreasonable. And that's not beyond the realm of contemplation. So
can I interrupt for a moment?
Really undermine
what do you mean, counsel, to say someone could pick off, cherry pick from outside? What are you talking about?
A power marketer that would like to sell to one of the distribution cooperative members of Wabash Valley could attempt to undermine the integrity of the entire enterprise by attacking the formulary rate tariff, saying that it's unjust and unreasonable because it excludes them or it excludes it handcuffs the ability of one of the distributors to buy power from someone else, and say that the rate is that they've all agreed to is unlawful and unjust and unreasonable. That essentially deprives the G&T and its members of the ability to protect their long-term contractual arrangement, including the rates. I mean,
What about a consumer group? Could a consumer group attack this?
well, the purpose of the Mobile Sierra clause, as clarified in the NRG Power case, is to protect it from all comers, so including the non-contract parties.
But if you did not have the public interest standard by contract, a consumer group would more easily be able to attack this as the standard, just and reasonable calculation on the part of FERC.
Yes, anyone could. Yes.
Would the contract make a difference in that case? I mean, wouldn't FERC simply apply the standard FERC was going to apply? Like, could the contract change the standard that FERC applies?
Well, Mobile Sierra does implicitly do that. Yes, it says that FERC is required to presume that a contractually agreed upon rate.
No, I understand that, but the inclusion of a Mobile Sierra clause, would that change?
Yes. Yeah. Well, the case law is that if the contract is silent, but it's a fixed rate or a long-term contract, Mobile Sierra applies to that contract by default. And so the rates agreed upon are protected by default. That's the case law now. And
could I ask you about
including a Mobile Sierra clause clarifies beyond peradventure what the rules are, I guess.
Could I ask you about how the system worked under the old contracts? So the old contracts, the members agree to rates established by the board of directors. But there's a very important caveat in that, which is the revisions don't become effective unless and until FERC approves them. So FERC has been reviewing these rates. Did they review them under the ordinary just and reasonable standard or under the public interest only standard?
They reviewed them in 2005 when the formulary rate tariff was applied under the ordinary just and reasonable standard.
But the changes to the rates.
The rate is the formula. And so Wabash Valley is not required annually to update that with a filing at FERC under Section 205. So the rate.
But whenever they seek to change a rate, whether in 2005 or later, FERC reviewed that under the ordinary standard, correct?
Yes.
Okay, so that if the antecedent arrangement was board of directors sets the rate subject to ordinary just and reasonable review, right? That's what Tipmont and all the other owners agreed to. And now Tipmont and all the other owners are having imposed on them the different standard of review over Tipmont's objection. Why isn't that an abrogation of the old contract?
Well,
you're imposing that on Tipmont without Tipmont's agreement.
The procedure's not changed. The operative language of the contracts is the same, except for the Mobile Sierra clause in Section 22. Everything else is the same. I think the 1977 contracts were written before Wabash Valley was regulated by FERC, and so that they have a bit more general reference to regulatory authority. But when the contracts were filed and the formulary rate tariff in 2004, FERC said the 1977 contract allows FERC to review the formulary rate tariff, and it's consistent with the contracts.
Under ordinary just
Yes.
standards.
But
So that's like, I mean,
But that-
I read the old contracts as effectively having a Memphis clause. Right, the parties are preserving FERC's ability to review the rate under ordinary, just, and reasonable standards.
well, the contracts then were silent as to the standard that applied.
They explicitly said the rates don't become effective until FERC approves. And if you construe that to mean only that FERC reviews for just and reasonable, for public interest, then A, that's not what actually happened based on what you told me, and B, that contract provision would do nothing, since public interest review is a non-waivable feature of the statute anyway.
Yes. Well, in 2004 and 5, when the FERC, this is before Morgan Stanley, FERC's position was that when a contract is first filed with them, they review it under the ordinary, just, and reasonable standard. Morgan Stanley reversed that rule and said that the Mobile Sierra applies when that FERC is required to apply the Mobile Sierra presumption when a contract is first filed.
Unless the parties contract around that default rule.
Yes.
By the Memphis clause.
Yeah. Well, the FERC in the, as I recall, in the 2004 order where they accepted the formulary rate tariff and the contracts for filing, they dealt with this contractual language and said, which was contemplating state regulation of Wabash Valley in 1977, and said that it was consistent with Section 205, and it enabled Wabash Valley to file the contracts, notwithstanding the reference to other regulatory authorities. And
suppose the old contracts had said the following: Board of Directors gets to set the rate, but FERC gets to review the rates, and then it had one more step from the actual contract, which is it explicitly said FERC's review is under ordinary, just, and reasonable standards. If that was what the antecedent contracts had said, this amendment would be no good, correct?
Well, I mean, the parties have agreed to this amendment.
Tipmont hasn't.
And they didn't sign a contract. I mean, so
No.
that doesn't matter. The 20 members, 21 members agreed to it. Tipmont was given the opportunity to keep their existing contract, and they did. So how they're not made any worse off. They offered a better deal, and they turned in Wabash Valley's view, and they turned it down. So they're
Right.
still.
You said earlier that the tariff rates, this arrangement is not severable by owner. The tariff rates are going to be what they're going to be, and they're going to apply to Tipmont no less than to the 22 owners who approved the contract, right?
That is correct.
So all of the owners, whether they approved the new contract or not, are giving up their antecedent right to have FERC review the rates under an ordinary, just, and reasonable standard.
Well, I think they gave up that right when the contracts were filed at FERC under Morgan Stanley.
Which
Morgan
contracts?
Stanley.
Which contracts? I'm a little confused. The
Yeah.
original contracts or the amended contracts?
I believe Judge Katz's question was about the original.
At the original, right.
Yeah.
In other words, I understand your argument that the original contracts don't have a Memphis clause because they're silent on the standard of review. And we can debate that point. I'm just saying, if they did have a Memphis clause, I don't see how the amended contract would be valid because it is imposing the new standard of review, and therefore the new tariff rates on the objecting members. It's abrogating their antecedent contract, which includes the right to FERC review.
Assuming there was a Memphis clause in the original contracts, I think you may be correct.
So this ultimately comes down to how we should construe the original contracts, which on the one hand say FERC gets to review rates, but on the other hand is silent about standard of review.
Yes, under Morgan, but of course, in these orders, FERC undertakes none of these examinations of fact-finding of any of the contractual relationships between the parties, either in 1977, 2006, or today. And so FERC has made none of that kind of fact-finding inquiry and has not construed the original contracts.
Fair enough. But if we're construing Mobile Sierra rather than construing a discretionary decision by FERC, I'm not sure that matters.
But
I would like to make sure I understand what I thought the new contract simply extended the period of time. Isn't that correct? And
they do.
And immediately extended the period of time and immediately applied a public interest standard.
Yes.
To the existing contracts.
No, to the new contracts.
To the new contracts which replaced the existing contracts.
Yes. Yes.
Okay.
Yeah.
So the old contracts are null and void under your theories.
Only to the signatories. There are two members who did not sign the new contract.
Now that's what I really want to focus on.
And
So
they kept the existing contract.
The two members that didn't sign, therefore, have the benefit of the old contract, at least up to, what is it, 2050. So they were perfectly fat and happy with the old contract up until 2050.
They are bound by them. I don't know how Titmont is in other
Titmont,
litigation is attempting to terminate that contract, but
okay, now I'm really confused. Titmont wants to terminate that contract?
they do. In other litigation, they're attempting to do so before the 2050, immediately.
For what purpose?
So they can purchase from someone else.
Yeah, that's what I thought. So they have that option. Does that make them have bargaining power in your view?
Well, they have the option to buy out their existing contract, and the dispute between Wabash and Titmont, which is in litigation at FERC right now, is the amount of the buyout and the period of the buyout, the notice period. And that gives Titmont some bargaining leverage, yes, in answer to your question.
Interesting.
But the important, a key thing that I think I don't want the court to lose sight of is that the formulary rate tariff is a cost-based rate already approved by FERC. It's just and reasonable. It's going to apply to all the members under both sets of contracts. That's not changing.
Let me ask you again, what do you know is the position of Titmont as to why they didn't want to agree to the modified contract?
They didn't like the extended term. They didn't like some of the provisions that dealt with the respective rights and obligations of Wabash and the members to implement PURPA, to buy from qualifying facilities. They wanted to retain the ability to purchase from qualifying facilities, distributed generation. They wanted more liberal rules to allowing them to use local distributed generation rather than buying from Wabash Valley.
But
they wanted a looser.
But their challenge here is to the public interest standard.
Well, yes, I mean, they've intervened in support of Ferc here. But if you go look at their protest, pages 16 to 18 of their protest back in the joint appendix, you'll see they didn't raise any of the arguments that are in Ferc's orders about Section 22. In fact, they made a claim that the contracts, Section 5 and 11, prevent them from filing any protest to the rates and deprive them of all rights. And that's clearly not the case because they retain the rights to file a complaint under the public interest standard. So they overplay their hand in their protest. They object to the contracts on for many reasons, if you see in their protest in the joint appendix. But the argument that we're now having about the formulary rate tariff was not one of their arguments. They've never protested the formulary rate tariff or sought to change it at FERC. So
I'll have some
FERC's
questions.
issue is completely separate.
I'll have some questions for the intervener on that respect.
Okay. Judge Silberman, anything else?
No, sir.
All right. Thank you, Mr. Elliott.
Thank you.
Ms. Pasella, we'll hear from you.
Good morning, Your Honors. Consistent with the Supreme Court's, this court, and the Commission's precedent, the Commission reasonably rejected Wabash's proposal to require the Commission to presume the justness and reasonableness of Wabash's tariff, not its contracts, its tariff, since its terms are not individually negotiated, but are set by Wabash's board of directors and apply generally.
You're not suggesting that that term formulary tariff is inconsistent with a contract, are you?
Yes, the Commission found that the tariff is not a contract, Your Honor.
No, they found that there was no contract here, but not because of the label of formula tariff.
No.
Okay,
No,
okay.
because the tariff is generally applicable and it is not individually negotiated
Now,
between Wabash and the members.
Here's my questions for you on that. Suppose two companies negotiate with two distribution companies, negotiate with together with a power company. Is that, in your view, automatically a tariff because there's more than one company negotiating?
No, if it's individual negotiation, if each of the members is actually part of that negotiation and is able to do, because listen, the underlying premise of Mobile Sierra, Your Honor, is that in wholesale markets.
Counsel, I'm just trying to understand your position before the argument. So if four companies were to agree to bargain together with a powerful generator, that would be perfectly all right as a contract under Mobile Sierra.
Yes, because that would have the arm's length bargaining, the parties with adversarial.
Then why do you use this term individualized? It doesn't make any sense.
It's individualized negotiation, Your Honor. So the point is that it has to be, each individual has to, on who's going to end up, I'm sorry, Your Honor.
I think Judge Silberman's hypothetical is two powerful owners make the structure we have here, which is they create a co-op, which has a board of directors, which negotiate or sets the rate.
In other words, by the use of the word individualized negotiation, you don't mean it has to be a negotiation with just two companies.
No, it means it can't be by majority vote, Your Honor. So the problem with the tariff being subject to Mobile Sierra presumption of justice and reasonableness is that you don't have what the underlying premise, and forgive me for going back to that, but I really think that that's the key to this case. The underlying premise of requiring the Commission to apply the presumption of justice and reasonableness to contracts is because in wholesale markets, the party charging the rate and the party charged are often sophisticated businesses enjoying presumptively equal bargaining power, who could be expected to negotiate a just and reasonable rate as between the two of them. So that's where the Commission is getting the individual language from. It's because it's between the two of them. But that can happen the same way if it's a room filled with everybody, if everybody's there and everybody doesn't just get an equal vote, but they can't be overruled by the majority. That you have to have an individual negotiation. You have to be able to go head to head with your equal bargaining power. And that's not what occurs regarding the tariff here.
So in this case, if you had the same structure, board of directors, in which the provision was, we do not have a position with respect to the contract relating to the rates unless you have unanimous agreement, then you would say that's Mobile Sierra.
I think that the commission would find that it part of the problem is solved for sure. I think yes, arguably the commission would find that because you would know that these entities with equal bargaining power had the opportunity to get in there and actually negotiate something, and that's why you can presume it's just and reasonable.
I see. So even if all the parties agreed in this case, the fact that the provision requiring majority vote would be objectionable to FERC, even if none of the members objected.
That's right, Your Honor, because it's going forward. The board can change the rate going forward, right? And that's fine. The board can change the rate going forward. The problem is you can't then presume.
That is a very interesting response to my question, but why didn't FERC say that?
FERC did say that. What the commission said in the orders was, first it said the Mobile Sierra presumption, public interest presumption applies only to rates set out in a freely negotiated wholesale energy contract. That's in paragraph 12 at JA 184. And then it explains, thus, to ascertain whether the instrument at issue is a freely negotiated contract, the commission determines whether it embodies an individualized contract.
Council, FERC did not say the point that you made. Now, it may well be under Morgan, we can consider matters that FERC did not rely on. But they certainly didn't say what you just said, which I must say makes more sense than the FERC order. FERC never said. The problem with this case is that you have majority vote amongst the members that could bind members who disagree, like Titmont.
I think that you can discern that from the commission's order, Your Honor, if you forgive me. Let me point you to rehearing order at JA 223, paragraph 15, where the commission said the Mobile Sierra presumption doesn't apply to this formulary rate tariff since it's generally applicable and it's not negotiated between Wabash and its executing members on an individualized basis. Rather, the Wabash Board of Directors determines the rates provided in the formulary rate tariff. And we know from the record that means
you can stretch on that.
Well,
and maybe
it's discernible.
It's a very interesting point, Council.
So would Mobile Sierra apply to this set of contracts if the members had unanimously approved them?
If the members had unanimously approved the tariff, the provision regarding the tariff, because again, the commission's orders are only regarding the tariff, not regarding the contracts. The commission did not rule whether the contracts could have a Mobile Sierra presumption. If all of the members had agreed, I think not, because the commission said it also is a generally applicable tariff, and that's the other part of the commission's holding. There are two criteria that are alternative, and one is that it's generally applicable. The other one is that it has to be individually negotiated. And so I think the tariff could apply to new members that join. And it's not hard. And as we pointed out in our brief, it's not hard to become a member of Wabash Valley. You really just have to apply and you agree to agree by the bylaws and whatever other rules there are. So it's not difficult to become a member. It's not
The
inconceivable.
petitioner says that's speculative, that you don't know how they would treat a new member.
Well, we know that the tariff applies to all Wabash members. That's conceded and that's a given. So anyone who's a member of Wabash Valley has to pay that tariff rate. And if it's subject to the public interest standard, that entity certainly hasn't agreed. And we know under NRG that this is going to be applicable to third parties. So new members would have to pay a tariff rate, not have the ability to challenge it as not being ordinary just and reasonable standard, but only could challenge it for purposes of.
I don't understand the
interest.
generally applicable as being a different point from the individualized notion. What do you mean?
So the commission's point about that is that it would automatically apply to new members, not just, they weren't even there to potentially try to individually negotiate this because they weren't members at the time. But because the tariff automatically applies to all Wabash Valley members, that is a generally,
that's really quite related to the question I was trying to get to, in which Judge Katsas pointed out. What if if I understand the logic of your position, even if everybody agreed in this case, all the members, all the distributors agreed, you would say it's still the provision that allows majority rule to govern makes it inconsistent with an individualized, whether your strange use of the term individualized, and therefore would not qualify under Mobile Sierra. Is that correct?
that's right, because
whether or not anybody disagreed in this case.
Yes, because that tariff with the Mobile Sierra presumption of justice and reasonableness would apply to new members as well, and they were not part of this negotiation.
No. Even if there were no new members, your position is even if this didn't apply to new members at all, there was no question about that, you would say, if I understand you correctly, even if we only deal with the members that we have, the provision in the contract that requires majority rule is inconsistent with individualized negotiation.
Yeah, that provision is not in the contracts, Your Honor, it's in the bylaws, but yes, that provision makes it innately, because it makes it innately inconsistent with being able to presume that entities with equal bargaining power got together and negotiated something. That's why we can presume that the rate is just and reasonable, because when you have wholesale sophisticated entities doing that kind of bargaining, you can presume that they'd come out to a just and reasonable rate. But that you can't presume that when not everybody actually gets their say in this negotiation.
What do you make of the observation, which Judge Katsas and I perhaps disagree as to the significance, that in this case the members are on both sides of the transaction? What do you make of that?
For sure, the Supreme Court and this court's case law do talk about the importance of arm's length negotiations, and arm's length negotiations have to be between adversarial parties with different interests. And I think that arguably not even arguably, I mean, these are all member owner customers. So they are both buyers and sellers here, and they have a common interest. These are not arm's length. But that's really, I think, more towards well, maybe not. It is a tariff question too. I think I know that the intervener Titmon talks about, either in the record or in their appellate brief, talks about how not every member has the same purchasing. Some buy more than other entities in within Wabash Valley. And so even though each member gets an individual vote, some parties might be more interested in trying to get a rate set higher than someone else, because these are also competing entities. So it's kind of an interesting quagmire there. So the one equal vote it's not really based on how much you actually purchase through Wabash Valley. And I'm sorry, Mr. Elliott, please correct me if I'm not correct about that. I think it is important to recognize that FERC does while we don't get deference in interpreting the Supreme Court's case law, we do get deference in applying that case law to these facts. And what the commission found here is in this unusual circumstance, this is not a typical Mobile Sierra provision in a contract. This provision not only binds the commission and others to public interest review regarding the contract itself, but also regarding the tariff. And that is unusual. That is not a typical circumstance. And it is extreme. And it's not the type of, a tariff is not the type of contract that Mobile Sierra is intended to apply to. It's not a contract. And even though it's not unilaterally set, the tariff rates by Wabash staff members, it is unilaterally set by Wabash's board of directors. And that is not something to which Mobile Sierra can apply.
Ms. Pacelli, if I could just ask you a question, I also asked Mr. Elliott. I mean, can parties change FERC's standard of review by contract?
I think if Your Honor, I think if they can by including a Memphis clause in the contract, right, with Mobile Sierra being the default. And again, it has to be a contract first for that to apply. Mobile Sierra presumption only applies to contracts. But so I think in that way they can change the standard of review.
But can they require FERC to apply the Mobile Sierra presumption to things that FERC determines are not contract rates?
Absolutely not, Your Honor. Mobile Sierra presumption only applies to contract rates. And again, it's based on that underlying presumption that you can presume rates are just and reasonable because this head-to-head negotiation occurred.
You know, I have a question about that footnote in the FERC opinion that they don't reach the Mobile Sierra question at all. Well, I found that a little puzzling because don't you have to answer the question, discuss the premise of Mobile Sierra, whether this is a contract or a tariff? And in considering that, you have to consider whether or not there's arm's length bargaining between roughly equal parties with equal bargaining power. Isn't that right? So it's a little artificial to say, as FERC says, we don't even reach the Mobile Sierra question because they have to consider the premise of Mobile Sierra, whether this is a contract or a tariff.
Sure. What the footnote in each order that you're referring to, Your Honor, says that what it says is the commission didn't reach whether the contracts are subject to Mobile Sierra presumption, whether that's okay or not. What the commission's whole orders are about is whether the tariff is subject to the Mobile Sierra presumption. So the whole point of these orders is about Mobile Sierra and applying Mobile Sierra
to
Mobile Sierra cases.
So I was overreading the footnote.
Yes, Your Honor.
I see how you're dividing that, but it's almost metaphysical.
Well, no, the point is, FERC is saying, FERC, it addressed the big issue here, which was, can you apply Mobile Sierra to something that's not a contract rate? It's a tariff. So the
problem with that, it assumes the conclusion.
No, the commission's point, that's what it addressed in it. It didn't assume the conclusion. The commission determined that it's not a contract rate because it's generally, the underlying assumption doesn't work in a circumstance where you have The board of directors making the determination what the rates are going to be.
Okay, okay, I understand it. The key to your whole case is the provision requiring each member to comply with the majority vote of the board of directors. That's the key to your case.
Yes, is that the board of directors does it, and as the record reflects, that is by majority vote. Yes, and that is what the commission said in paragraph 15 of JA 223. These are not negotiated on an individualized basis. The tariff is not the tariff rate because the board of directors determine the rates in the formulary rate tariff. Again, there's no problem. The commission's not saying you can't have the tariff rate be the contract rate. And the commission is not saying that can't change over time. The commission is not saying that here. The commission is just saying you can't require the commission to presume that that will then be just and reasonable because this is not a negotiated rate.
So your view would be entirely different if the bylaws required unanimity.
Yes, that would be a completely different circumstance, Your Honor.
What one you would treat as a contract under Mobile Sierra.
And I think I was saying before, the commission also found that it's generally applicable. The tariff is generally applicable. So I think there's that wrinkle there. Again, when you look at the way the commission determines, when it explains in paragraph 14 at JA 222 to 223, when it determines whether Mobile Sierra presumption can apply to an instrument, it looks at in the second.
Wait a minute. Let's talk about it generally applicable.
Mm-hmm.
If under the bylaws you had to have unanimity, and other members could be brought in, and they would have the same benefit, it had to be unanimous.
So if new members would have it, okay, I see what you're saying, Your Honor. So it's generally applicable, but everybody gets that actual vote, that those entities themselves will have an opportunity to determine the rate. That's a circumstance that wasn't before the commission, so it's hard for me to speak for sure. I guess there would be some period of time before the year. We don't know how often the board is changing the rate. There's some period of time where these new entities would be subject to that tariff rate without being able to challenge it, except under the presumption of justness and reasonableness. So,
well, no, they wouldn't. No, by contract, they wouldn't be bound unless they agreed.
So,
under my hypothetical.
So, in that circumstance, I think the commission would not have an issue with that. I think the commission would find that the underlying premise of having of the Mobile Sierra presumption of assuming that something is just and reasonable would be satisfied in that circumstance.
Thank you.
Judge Silberman, anything else? Judge
No.
Rabb?
No, thank you.
Thank you, Your Honors.
Ms. Patel, Mr. Elliott, we'll give you 2 minutes.
Thank you, Your Honor. As a preliminary matter, just to clarify one point that Ms. Pacello raised, and that is that it is a one member, one vote rule in the board of directors at Wabash Valley. Each member has an equal vote, and that's true not just in Wabash Valley, but every cooperative in America that I'm aware of. The focus on that point of the democratic governance of the cooperative and how that is somehow inconsistent with Mobile Sierra is a dramatic extension of the Mobile Sierra doctrine that I don't know if there's any basis in any case law anywhere for that. The case law in Mobile Sierra.
Well,
can you point to?
Oh, excuse me.
Oh, sorry.
Go ahead, please.
Okay, sorry. Can you point to any case where where FERC has applied the presumption to a cooperative with a similar structure to Wabash's? Since you said those is a pretty common structure.
Yes, but there are only about 8, by my count, cooperatives who are regulated by FERC. Most of them are not regulated by FERC statutorily. So there are only a handful of them. And this issue has not come up very often. There was a case involving Old Dominion Cooperative that I think is referred to in some of the orders cited in the FERC orders here that applied a Mobile Sierra presumption to a member's long-term contract, all requirements contract. But a tariff, like we're talking about here, has never come up before.
And FERC's involvement is sporadic because many of these arrangements involve intrastate transactions?
Well, they're just statutorily exempt because a lot of cooperatives are borrowers from the Rural Utility Service,
Okay.
the federal agency, and statutorily are exempt. So Wabash Valley is not, and there are a handful who are not.
Okay.
So they're regulated by FERC. Important point that I think FERC Council has emphasized here is that Wabash, the FERC orders do not reach the question whether these contracts were freely negotiated at arm's length. They presume they were and reject this Mobile Sierra clause, even if they were. So there could have been unanimity, the perfect contracts, perfectly negotiated. FERC's rule is that you can't do it this way. You cannot protect the mutually agreed upon contract rate through a common tariff controlled by the board of directors. We've had a wide-ranging discussion today about the negotiating power and bargaining leverage, and none of that is in the FERC orders, of course. So I think there's really no question. You have to remand this for a more searching examination of the real issues by the commission, because this Delphic one-paragraph explanation that is just completely inadequate to constitute reasoned decision-making. So I would leave you with that point that I think the orders here are just completely deficient as a matter of reasoned decision-making. They haven't grappled with the real issues of why Mobile Sierra should apply or not to this arrangement.
Any other questions from the panel?
Oh,
Thank you, Mr. Elliott. The case is submitted. Should we plow ahead?
but of course.
All right, please call the next case, Madam Deputy.
Case number 20-5181, Eugene Hudson Jr., appellant versus American Federation of Government Employees. Ms. Morton for the appellant, Mr. Sanghvi for the appellate.
All right, Ms. Morton, whenever you're ready.
Good morning, and may it please the court. I'm Kimmy Morton, appearing for Mr. Hudson. I wanted to address an issue that we talked about in our reply brief, and that is that whether Local 1923 is composed solely of government employees. As we stated, the district court erroneously ruled that Mr. Hudson is a federal government retiree, and all of the cases cited below involve federal employees. But Mr. Hudson has been a private sector employee and dues-paying member of AFGE and its local affiliates for the past 32 years. So when Local 1923 admitted him in September 2018, we know for a fact they have one private sector employee, which we believe makes it a mixed union subject to the Labor Management Reporting and Disclosure Act of 1959. And in fact, in our third amended complaint, which the district court denied as moot, we challenged AFGE Local 1923's claim that it is not a mixed union because they had not produced a list of all of the bargaining units that were represented by Local 1923. We believe the court erred in divesting itself of jurisdiction before ascertaining whether in fact Local 1923 is composed solely of government employees, or whether, as we claim, by admitting Mr. Hudson, it is a mixed union and therefore subject to the act.
I don't understand.
Secondly,
sorry, could I just ask you about what is the relevance of his private employment? I mean, he did work for the union, that's true, but this case arises out of his loss of membership in the union. And he became a member of the union because he was employed by the federal government. And when he retired from the federal government, he converted from active membership to retiree membership. So all of these membership issues grow out of his former federal employment. And it wouldn't have mattered a bit if he left the federal government to work for the union or work for General Motors.
Well, that's the problem, Your Honor. He never retired from the federal government. He resigned in 1989 from the federal government. And for 32 years, he worked for AFGE in the private sector. He doesn't have any money paid into the merit personnel system. He can't claim retirement. The FLRA, which is the agency that interprets the CSRA, found that he's not a government employee, and therefore they have no jurisdiction over his claims. And of course, the Chevron doctrine requires that you give deference to the interpretation of the FLRA, which has twice said he's not a government employee. That's why it's significant, because as a private sector employee, he cannot bring his claim under the Civil Service Reform Act, because AFGE is not a government agency.
Did you raise that issue below, counsel?
Yes, oh yes, we did. But unfortunately, the district court mistakenly ruled that he is a retired federal government employee when he is not. And we made that clear in our complaint, that he's a retired AFGE member, but he's one of a sliver of private sector employees who are able to join AFGE even though they don't work for the government. That's because AFGE in its national constitution has a provision in Article 3, Section 1C that states, if you leave the government voluntarily and you go to work for the private sector, you can still maintain your membership in AFGE. That's why, and one of the reasons why AFGE is a mixed union, because it allows people who have left the government and who are now in the private sector to maintain their membership in AFGE, as does Local 1923. It has the exact same provision in its constitution. Article 3, Section 1C is incorporated from the AFGE National Constitution into the AFGE Local 1923 Constitution. And before they admitted Mr. Hudson, the local contacted AFGE National's General Counsel, which we talk about in our complaint, and asked, could they accept his membership? And the General Counsel responded that yes, if your Constitution permits it. So once they invoked their Constitution and voted him in, knowing he was now a private sector employee, they now represent public sector and private sector employees, and they're a mixed union.
They don't know. They allow him to be a member, but they don't represent him with respect to his employment by the union.
Well, they have a duty to represent him if they're taking his dues every month. He's paying his membership dues just like the government sector employees are.
I mean, is there an order from a federal agency certifying a bargaining unit that at the union that includes him?
He would not be a member of a bargaining unit and under any circumstance, because he was a manager when he worked for AFGE. He was an officer and a manager and an employee who would not have been subject to a collective bargaining unit. But he's like other elected officials. Many other elected officials have come in the same way he did. They maintained their AFGE membership after they left the government, pursuant to that provision of the Constitution.
Ms. Morton, even if we accept your representations that he's not an employee for the purposes of the CSRA, couldn't he bring his claims under Section 7120 of the statute, which apply to members of public unions, and that under that provision, the Department of Labor has promulgated various regulations incorporating substantively the provisions of the LMRDA. So wouldn't that be an avenue for him to find relief?
He filed his claim under that section, but the FLRA dismissed it, saying he was not a government employee.
Did he file those claims though with the relevant division of the Department of Labor?
He initially, before he went to the FLRA, he filed it with the Department of Labor. The Department of Labor told him they had no jurisdiction. He had to file it with the FLRA. So he filed then with the FLRA, and the FLRA also dismissed his unfair labor practice complaint because he was not a government employee. But, you know, I draw your attention to the Castellano, the Solis versus AFGE, the Castellano case that we discussed at length in our brief. And in that case, Mr. Castellano, like Mr. Hudson, had left the federal government. He had not yet retired from the federal government. And in the interim, he worked as a national representative for AFGE and was a member of AFGE based on Article 3, Section 1 of the Constitution that allowed him to maintain his membership. So he was employed again by the private sector. And the first issue that Judge Bates said in Solis versus AFGE, the first issue he articulated, even though this was brought by the Department of Labor and it's a different case because it was an election dispute, the first issue that Judge Bates raised was whether Mr. Castellano was a member of AFGE. And AFGE acknowledged that if the court found that he was a member under Article 3, Section 1C of the Constitution, then Mr. Castellano did have a right under LMRDA to go into federal court. That's in their pleadings that they filed in Solis versus AFGE, and we cite to their pleadings in our brief. And that is exactly what Judge Bates found, that Mr. Castellano, while he was in that interim position in the private sector, that his rights were, that he was a member under the LMRDA. That's the only analogous case we can find. All of the other cases involve government employees. All of the cases that were cited by Judge Boisberg involve federal employees, which he's not. He hasn't been for 32 years.
Okay, Judge Rao, any other questions? Judge Silberman?
No.
Thank you, Ms. Morton. Mr. Sangvi.
May it please the court, my name is Rashad Sangvi and I represent AFGE in this matter. I think the court hit upon the primary argument that AFGE has made in its briefs as well, and that is some background on Mr. Hudson's membership in AFGE. Mr. Hudson is a former federal employee. The appellant does not deny that, and he retained his membership in AFGE as a former federal employee. While he eventually left federal employment, as appellant's counsel has stated, he retained his membership under Article 3, Section 1C of the AFGE National Constitution, which allows former federal employees to retain membership. Hudson was also a staff member of AFGE, but he does not and could not genuinely contend that he derived his membership in AFGE based on his status as a staff member. Again, his briefing continually represents that he retained his membership in AFGE as a former federal employee. He was never a member of a bargaining unit, as counsel conceded, that was represented by AFGE. Thus, his status as a private sector employee and is irrelevant to his avenues of redress through the Civil Service Reform Act. And we'd also note, that Hudson didn't actually contend in the briefing below that there was any reason for the court, to grant him rights under the LMRA or LMRDA because of his private sector employment. Hudson did correctly note that he did not retire from the federal government, but he never stated, his employment at AFGE somehow granted him rights against AFGE as his labor organization. And so we think Hudson waived that argument on appeal. But putting that aside, and I think the court correctly hit on this, the Supreme Court and this court has consistently held that the statute, which is Title VII of the Civil Service Reform Act of 1978, created an elaborate and extensive administrative scheme of review for claims made by individuals and organizations within its coverage. Courts have held that if a remedy for a claim or an avenue of redress for a claim is available under the Civil Service Reform Act, it forecloses court review of that claim. In Secretary of the Air Force, in fact, this court held or suggested that even if the remedy available under CISRA, the Civil Service Reform Act, is not adequate, plaintiff may still be foreclosed from district court review. The courts in Stedman and Trump found that even constitutional claims are preempted by the statute if, again, you can assert those claims through the statute. And counsel noted that several of the cases involving Title VII or CISRA preemption discuss complaints against the government. But courts have made clear that complaints such as Mr. Hudson's by a union member against a covered labor organization are also preempted. The Supreme Court in Caraholius did this. So did this court in Stedman, a great decision, and the Eighth Circuit in Reed versus Sturdivant. And all of those cases stand for the proposition that a union member like Mr. Hudson of a covered labor organization must proceed through CISRA's administrative scheme. And, Hudson asserts the fact that he did file a complaint or a charge with the Federal Labor Relations Authority, alleging, that some of the claims he alleges here, and that the FLRA's regional director denied or dismissed that charge. However, there's a couple of points that the district court made that are relevant here. First, as the district court noted, the FLRA regional director's decision wasn't a final decision of the authority, and it was appealable. Hudson did not appeal that decision. And that decision did seem like it may be in tension with the statute. Next, and even more important is—
Could I ask you about that? I'm a little puzzled about how 7120 works, and we've sometimes said jurisdiction is concurrent as between the FLRA and the assistant secretary. We've sometimes said some 7120 claims go one way and others go the other. But I mean, the most favorable case for Hudson would be the one that his counsel represented, which is he tried to do both and they both rebuffed him. Now, I remember the FLRA track. I don't think that's particularly compelling because that part of the statute is limited to employees, but 7120 may give him an avenue before the assistant secretary under a standard that includes all members. And what's he supposed to do if he tries both and they are all giving him the runaround saying, no, we can't hear this?
So first, I'd just like to address, so the ULP route under 7116 is actually not limited to employees. So if you look, and it's at A110 of the appendix, that's the decision of the FLRA regional director not filing a complaint on Hudson's behalf. He alleged a violation of the statute under three specific provisions of 7116B that apply to employees. However, 7116B8 is extraordinarily broad, and it states that any individual can file a complaint against any labor organization based on any violation of the statute. And so Hudson could have, under 7116B8, filed an unfair labor practice charge against AFGE for violating, a variety of different parts of the statute, including 7120.
On the theory that 7120 protects all members and
correct
the violation of, I see, okay.
And there are other provisions in the statute, and we talk about equity and things of that nature that he could have asserted there. And again, I think it's important to note that the regional director didn't say that a member of a labor organization cannot file a charge if they're not an employee. The regional director said these three specific portions of the statute were not violated because Hudson didn't assert additional portions of the statute. And the FLRA has, again, held that former employees of the federal government are still covered by the statute. In terms of Section 7120, that's correct. That was another avenue, Section 7120D, for Mr. Hudson to have filed a complaint with the Department of Labor. The Department of Labor has promulgated regulations for complaints to be filed in that nature. And I don't believe Hudson had actually filed a complaint under those sections. He sent an email at one point to an employee of the Department of Labor, but he didn't specify, any regulations or provisions he thought were violated. If the Department of Labor did, for some reason, say, "Hey, we're not going to file anything for you," we believe Hudson could have still pursued his claims either through 7116B8, through, if the authority chose not to take action, he could have gone through 7123 for appellate review. And, again, I think a larger issue is, again, all of his rights derive from the statute, right? He is not a private sector. He never was a member of AFG through a private sector affiliate. Aside from the statute's existence, he would not have rights against AFG. And so regardless of whether or not there is some relief at the end of the day, any rights he have must be channeled through the statute. And so again, I think we believe the court was correct in finding that his claims here were preempted by the statute's multiple avenues for him to redress these issues against. And I think it's key again here that the local 1923, who's no longer a party to this case, is not a local covered by the LMRA. It's not a local covered by the LMRDA. The only statute relevant here that it's covered by is the Civil Service Reform Act and these procedures. Can
you give us do you have a sense of how common Mr. Hudson's situation is vis-a-vis the union? Like where he was a former federal employee, but then he was employed by the union and is still a member of the union. I mean, I'm just curious, I guess.
So there are many former federal employees who are employed by the union, but an important point there is Mr. Hudson as well, and I don't know if this was in the briefing, when he was an employee as opposed to an officer of the union, he was a member of a bargaining unit that represented certain employees of the union. However, that's a separate membership. That wasn't his membership in AFGE. That was his membership in Communication Workers of America.
Okay.
And that was when he was an employee again of the union in a bargaining unit that represented employees with the union as the employer.
Okay.
But there's a handful, maybe like 50 employees who these similar circumstances may apply to in that sense. Again, I note my time is up, but if the court wants me to elaborate on our arguments regarding the application of the LMRA, I'm happy to do so.
My colleagues have questions?
No.
All right, we'll take that on the papers. Ms. Morton, we'll give you 2 minutes.
Your Honor, Section 7116B8 is just a catch-all section. Our understanding is it still applies to agency employees and not employees of AFGE. We also would like to discuss briefly the argument under Waddell versus IBEW that in which the Supreme Court held that individual union members are the beneficiaries of provisions of the collective bargaining agreement may bring suit under 301 of the Labor Relations Management Act of 1947. And since Mr. Hudson's claims are that his rights to be a member were violated and were guaranteed by the AFGE Constitution, that Constitution constitutes a third-party beneficiary contract, which he has the right to enforce in federal court. That is the argument we're making on that point. And we believe that that argument should prevail even if the court believes that Local 1923 does not represent private sector employees. We also feel very strongly, and we'd like to reiterate that Local 1923, in fact, did consider the fact that Mr. Hudson was not working for the government when they admitted him as a member, and therefore realized they were admitting him as an employee of AFGE. We believe that of their 5,000 members, there are probably other members like him who fall into this very narrow category, and that he should have a right that should be protected under the LMRDA to go into federal court.
Thank you,
Could
Ms.
I-
Morton.
could I ask,
Go ahead, Judge
He did
Silberman.
file with
Could
the-
I ask counsel for the respondent, the appellee, to respond to the 301 argument?
Sure.
Yes, so initially I'd state on the 301 argument that preemption still applies, right? This is a claim that Mr. Hudson could have addressed through the Civil Service Reform Act, and so his claim would be preempted. Putting that aside, we don't believe in this. I don't believe this court or any other circuit has applied Section 301 to mixed unions. The court decision that Hudson relies on was a case in which Hudson himself was suing AFGE as an employee of AFGE and claiming he was a third-party beneficiary of AFGE's affiliations with private sector labor organizations who would be covered by the LMRA. First of all, we think that's a completely different scenario to the situation here, where Mr. Hudson is pursuing a claim based on his membership in a purely public sector labor union. It doesn't have anything to do with his status as an employee. But even putting that aside, 301 has never been applied to mixed unions, and for good cause. The case of this court that applied the LMRDA to mixed unions, Weilberger, took into consideration a couple of factors when applying the LMRDA to mixed unions. Initially, the court relied on a Department of Labor regulation that said the LMRDA should apply to mixed unions. No such regulation is there for the LMRDA or for Section 301. Next, the court in Weilberger relied on the purpose of the LMRDA. The LMRDA was enacted to root out, as Congress said, union corruption at the top, right? And so the court reasoned, if you're in a mixed union like AFGE, whether you're a member of a private sector affiliate or you're a member of a public sector affiliate, your leaders at the top of the organization are the same. And so for consistency, both the private sector and public sector employees should be able to pursue claims against those leaders. So those were the reasons the court in Weilberger held that the LMRDA was applicable to mixed unions. That does not translate to Section 301. The contracts of private sector affiliates and the contracts of public sector affiliates of a mixed union are different in nature because they're governed by different laws. The public sector affiliates of AFGE are governed by the Civil Service Reform Act. The private sector affiliates are governed by the NLRA. So there's a big difference there. There's also in the instant case, the issue of Mr. Hudson's, the contractual right he's trying to vindicate is the alleged contract between AFG Local 1923 and AFGE. That affiliation, as it's encapsulated in the international agreement. AFG Local 1923 is not a labor organization under the Taft-Hartley Act or Section 301. So there's really no contract between labor organizations that he's trying to vindicate here. So I think that's a
because it involves public sector.
Correct.
All right, thank you.
Good. May I respond, please?
Ms. Morton,
Yeah.
you are supposed to have the last word, so I'll give you a minute just on the 301 issue, please.
Yeah, one of the arguments we made at the 301 issue was that the national union's president coerced and encouraged and supported the locals' decision. And that is why we have jurisdiction under that provision of the LMRA. It wasn't just the local that made the decision. Mr. Cox had a demonstrated bias toward Mr. Hudson. And he did not intervene to stop the wrongful termination of his membership after the Department of Labor determined he had paid his dues. And he did that because he wanted him out as a competitor. And so that's why we believe we have jurisdiction under that section.
Thank you. The case is submitted.
Honorable Court is now adjourned until Wednesday, September 15th at 9:30 a.m.